importance about open disclosure is that it is the right thing to do. It is part of our professional obligations to patients to make sure that they get a frank and a fair assessment of things that go wrong to them. But it's also, I think, in the interests of clinicians and health institutions to do open disclosure, because it's an important part of their defence mechanisms. So I think we all have seen circumstances where patients will move towards suing a hospital or a doctor because they don't know what's been going on or what's been happening. Whereas a patient who is fully informed, has had a fairly frank assessment of what's happened to them and what their condition is, and moves into the process of talking about what can then be done to help them, is less likely to sue. So I see open disclosure not just as the right thing to do, but as a sensible thing to do to protect hospitals and doctors from claims. And there is some evidence for it as well. Research in the United States, in the UK, and even in Australia now shows that one of the principal reasons for people to sue their doctor is because they did not get an explanation afterwards. And we already know that many cases and claims against health practitioners results from poor communication. And open disclosure is good communication after there has been an adverse incident. And that doesn't mean that a doctor is negligent. It is not an admission of liability to undergo the open disclosure process. It's just a good communication with the patient so that they know what's happening to them, understand their position, and build more trust with their health practitioner as well. Now, insurers and government understand this very well. And that's why most governments, and including the Victorian government, legislated some time ago to make it clear that it is okay after an adverse event to say sorry to a patient that this has occurred to them, sorry that we didn't get a perfect result, or even sorry that something went wrong. And by saying sorry and going through that process, by law now, that is not to be taken as a legal admission of liability. We can waive fees, we can apologise, and at law, we are not admitting negligence. And I think that's a very important message that the government has given us to say that this process of open disclosure is not just the right thing to do, but important for our health system as well. And I think the way we do it needs to be important. We have open disclosure policies and processes. The Victorian government has a policy document. Most hospitals will have a policy document that says if we're going to do open disclosure, we don't do it badly, we do it well. And so we need to make sure that the right people do it, that we do it promptly, that we do it with the right attitude, that is as empathetically as possible, and that we give as much information to the patient as we can legally to explain their position. And even if we don't have all of the facts assembled, even if we don't know everything about what's happened, we can still see a patient fairly promptly after an adverse event and tell them that something has gone wrong, apologise that it's happened, and let them know that we're investigating and we're trying to find out more information. The person who does it should be the clinician, but supported by the management of the hospital as well. We don't want to rush into it, even though we do want to be prompt, and we want to be very clear about what we can say and what we can't say. It may be that we need to carry out a formal investigation, and it may be an investigation which is organised through legal processes so that the information is protected. But at the end of the day, we say to the patient as much as we can, as honestly and as fairly as we can, whilst at the same time making sure that we do all of the usual things we would do where there is a potential claim. So we would notify the insurers, we would seek legal advice, we would have management involved, but at the end of the day, it is about getting to the patient as quickly as possible. The worst thing that can happen is a patient wakes up after surgery, understands that they haven't got a perfect result, won't find out information because the nurses are avoiding them, the registrar won't talk to them, and everyone says you'll need to speak to the consultant, and the consultant hasn't come to see the patient for some time. That patient has immediately gone into suspicion, fear, and ultimately blame, and we're already on the pathway to seeing the lawyers before we've had a chance to do really good open disclosure. So the big message here today is that it's important to do it, not just because it's the right thing to do, but because it's a good defence mechanism as well.